everyone, welcome to Legal Bytes. I'm Alyte, and on this channel we explain the law one bite at a time. Today we're going to give an update on the Epic Games v. Apple lawsuit. The court made a determination on Epic Games' motion for a preliminary injunction, and as a result, Fortnite is still not back on the iOS App Store. Is Fortnite doomed? Coming on up on Legal Bytes. So if you've been following this lawsuit, you know that the two companies just went head-to-head recently on something called a motion for a preliminary injunction. There was a hearing on September 28th, and even though they allowed up to 500 people to tune into the proceedings through Zoom, there was enough interest in the hearing that actually a lot of media got locked out and had to watch through unauthorized reproductions of the hearing via streams on Twitch and YouTube. The hearing lasted several hours, and although the judge in the case really seemed to nail Epic Games a few times during the hearing, it wasn't entirely clear how the court would decide the issue until it issued a written order on October 9th. So in this video, we'll go over what the basic issues were, how the court decided and why, and whether Fortnite is now doomed. As always, we have timestamps in the description below, so be sure to check those out. Let's get into it. So to really understand the significance of these issues, you need some basic foundation first. And that's basically to say, what was Epic going for and why? I'm gonna assume that if you're watching this video, you're probably already familiar with the basic claims of the lawsuit, like unlawful monopolization, unlawful restraint of trade, and tying. If not, we have a number of videos explaining the background of the lawsuit and the legal framework for the case. So if you need some background, be sure to check those out. Okay, moving on. As we all know, in early August 2020, Epic Games published an app update to Fortnite on the iOS App Store and the Google Play Store. On August 13th, 2020, Epic Games released a new feature on Fortnite which had previously been hidden from Apple and Google. The feature allowed Fortnite mobile players to buy Fortnite V-Bucks directly from Epic Games rather than through Apple's or Google's respective versions of in-app purchase. The V-Bucks sold directly from Epic Games gave a nice discount to players, incentivizing them to use that option rather than in-app purchase. As a result, and as again we're all familiar, later that day Fortnite was kicked off both mobile platforms, and Epic Games then turned around and filed separate lawsuits against both Apple and Google that same day. The next day, Apple also informed Epic Games that it would revoke all of Apple's developer tools from use by Epic Games and its affiliates. The affiliates include Epic International, Life on Air Inc., Psyonix LLC, and Quixel AB. This is significant because these affiliates run programs like Unreal Engine, which are used by third-party app developers to create, update, and run their apps, which are marketed on the iOS app market themselves. Basically, if access to Apple's developer tools by programs like Unreal Engine get interrupted, that could have a huge disruptive impact on the viability of these third parties that otherwise have no relation to the lawsuit. Apple notified Epic Games that Apple was giving them 2 weeks to cure Fortnite in order to re-platform Fortnite and return Epic Games affiliates access to the Apple developer tools. What that basically means is that Apple was saying that if Epic Games released a version of Fortnite that didn't give players the option to buy V-Bucks directly from Epic Games, Apple would allow Fortnite back on the iOS App Store, and it would give back Epic Games and its affiliates access to Apple's developer tools again. In response, Epic Games 3 days later filed a motion for a temporary restraining order, and a couple weeks later filed a motion for a preliminary injunction. A temporary restraining order, or a TRO, and a preliminary injunction, or PI, are really similar to one another. They both ask the court to issue an injunction while the parties are still in litigation. What that means is that the plaintiff asks the court to order the defendant, in this case Apple, either to affirmatively do something or to stop doing something. Really, the only difference between the two is timing. A TRO doesn't need a hearing before the judge in the case can grant it, but it can only last for a short period of time, like 10 or 20 days, depending on the circumstances. On the other hand, a preliminary injunction does require a hearing, but can last for the rest of the litigation. That's why you'll often see a plaintiff going for a TRO to get a quick emergency result, and then a preliminary injunction to solidify that result. TROs and preliminary injunctions come from the reality that lawsuits take really a long time. Courts recognize that sometimes, in the amount of time it takes to bring a lawsuit to trial, the plaintiff can end up irreparably harmed because of something that the defendant is doing or not doing, and which the plaintiff has really no control over. developer. So in this case, Epic Games filed a motion for a TRO and then a motion for a preliminary injunction. Specifically, what they were looking for was to have the court issue two orders. The first was to force Apple to allow Fortnite back onto the iOS App Store, and the second was to force Apple to allow Epic Games affiliates to regain access to those developer tools. The court ended up denying the first request and granting the second request. I'll get to why in a minute, but first we need to go through what Epic Games needed to show in order to win on these issues. To get a preliminary injunction, the plaintiff needs to prove four main elements. First, they have to show that the plaintiff is likely to succeed on the merits of the underlying case. Second, that irreparable harm is being done to the plaintiff. Third, that the balance of equities tips in the plaintiff's favor. And fourth, that an injunction is in the public interest. Now, on top of that, California courts will use a sliding scale approach to come to a decision on the issue. In other words, so long as the plaintiff makes a showing of all the other elements, the plaintiff can win if they can show that the balance of hardships tips sharply in their favor and they raise serious questions going to the merits of the case. So basically, the court can decide that because there's so much evidence in plaintiff's favor for element number 3, the plaintiff can win on a lower standard for element number 1. So what does that mean in concrete terms? In order to show the default standard, meaning that the plaintiff is likely to succeed on the merits of the case, they have to go through the basic claims from their complaint and go through each element of each claim to show why they're likely to win. At the same time, the defendant has the opportunity to give arguments as to why they think that the plaintiff isn't likely to win. Obviously, the court is going to look at the arguments from both sides and see if any of the issues can be resolved early. However, if there's a lot of conflicting evidence, or if there simply isn't enough evidence on the record, the court will say that the plaintiff hasn't met its burden of showing likelihood of success on the merits. Basically, if it's not super clear from the outset who is likely to win, the court is less likely to grant the motion. What's difficult about this is that if you think about it, it's almost like having a mini trial before trial. Before the two sides have had a chance to get evidence from one another through the discovery process, namely through document requests, depositions, and the like, the plaintiff has to essentially put on a showing that they're going to win when they finally get to trial. And make no mistake about it, the burden rests entirely on the plaintiff to make this showing. So it's a tall order, but there's really a good reason for it. It's because the plaintiff is asking the court to restrict the defendant in ways that the defendant is otherwise fully free to act under the law. Courts take very seriously the consequences of doing so, which is why it really is pretty difficult to get a court to issue a preliminary injunction. On the other hand, sometimes the harm faced by the plaintiff is so bad that courts are willing to loosen the rules a little bit to prevent, for example, total destruction of a business or loss of life or other lingering health issues that could result otherwise if they don't grant the injunction. In cases where the plaintiff is facing a potentially devastating harm, and where that harm is worse in comparison to the harms or inconveniences that the defendant would be facing under the injunction, courts will allow the plaintiff to meet its burden by simply showing that they've raised serious questions as to the merit of their claims. Meaning basically that the plaintiff doesn't have to show that they're pretty sure they're going to win, but that there's a pretty decent chance of it.
So you're telling me there's a chance? Yeah!
Finally, I want to make a couple last points before we move on to what the court decided and why. First, element number 2, irreparable harm, needs to be truly irreparable for the plaintiff to win. If it's possible in this issue for the plaintiff to be made whole simply by making the defendant pay money to the plaintiff, then it's not really the kind of harm for which courts will grant a preliminary injunction. Examples of harms that are irreparable are usually things like health and safety of people, destruction of historical sites, or harms which really can't be calculated. For example, if there's a dispute between two siblings as to the ownership of their parents' home after mom and dad had died, the court might enjoin the two parties from selling the home because of the emotional value that one sibling might place in keeping the home in the family. Likewise, if the defendant's activities have not only an immediate effect on the plaintiff, but also second or third order effects on other people or entities not in the litigation, the court will be more likely to find it appropriate to issue a preliminary injunction. And finally, courts do not like granting preliminary injunctions where the plaintiff has what's called unclean hands. Basically, where the plaintiff is somehow responsible for causing the harm through some kind of bad act, or where they really have some measure of control over the situation leading to the harm, courts are much less likely to grant the preliminary injunction. This basically comes from the idea that the whole point in a preliminary injunction is to return the situation back to the status quo. It's not meant to allow a plaintiff to act poorly and then escape the consequences of acting poorly. An example of a proper PI situation is where a residential neighborhood exists, and then a business starts operating a factory nearby. And then that factory starts releasing chemicals into the air, and those chemicals are starting to destroy the residents' homes and causing the residents to suffer breathing problems, for example. Returning to the status quo would mean returning the situation to what it was before the harm started showing up. In other words, forcing the factory to stop operating in that location until the end of the litigation. Okay, so that's that for the basic understanding of a temporary restraining order and a preliminary injunction. Now we'll get into why the court rejected Epic Games' request as to Fortnite and granted it as to the app developer tools for the Epic Games affiliates. So as I said before, the court denied the preliminary injunction as to Fortnite and granted it as to Unreal Engine and Epic Games affiliates. I'll start with the Fortnite issue. Basically, the main reasons why the court did not force Apple to allow Fortnite back onto the iOS App Store are twofold. First, the court was of the opinion that Epic Games had unclean hands. According to the court, Epic Games willfully entered into a contract with Apple, they understood the terms of the contract, and then they knowingly breached the terms of the contract. Even though the judge noted in the hearing that Epic Games probably had some strategic reasons for the breach, it wasn't exactly necessary to breach it in order to start the lawsuit, and it certainly didn't need to stay in breach of the contract in order to continue the lawsuit. In other words, the court told Epic Games that basically, you reap what you sow. And along those same lines, during the hearing, the judge proposed the idea of allowing Fortnite back onto the iOS App Store with some conditions. Namely, Fortnite would take away the V-Buck direct purchase option, and Apple would set up an escrow account for the proceeds made from Fortnite's in-app purchase. Basically, neither side would touch the money made from the in-app purchase while the litigation was ongoing. And then at the end, whichever side won the lawsuit would get the proceeds. Apple's counsel at the hearing said that they'd need approval from Apple. Probably an appropriate response, but at least they sounded open to the idea. Epic Games Counsel, on the other hand, flatly rejected the idea. They had a number of reasons why, but one that stuck out was that they didn't think that they really needed to because it was their position that the terms of service that were responsible for kicking Fortnite off the platform constitute an illegal contract because of the ways in which they violate antitrust law. On top of that, it seemed like Epic Games was trying to present a position of moral superiority, like they don't want to degrade themselves by settling for anything less than a determination that Apple is violating the law. On the issue of the terms of service being an illegal contract, they may very well be right. I've said in previous videos I think Epic Games has actually a decent chance of winning this lawsuit, and I still think that. But they can both believe that it's an illegal contract and maintain their moral high ground and allow the Fortnite mobile users to access the app by taking the deal proposed by the court at the September 28th hearing. As the court noted, they could go back to the pre-August version of Fortnite and it wouldn't harm their chances at winning the lawsuit. And the escrow account gives them a way to both maintain their moral high ground and protect their users. All they would have to do is, if they win the lawsuit, they get the proceeds from the in-app purchases that have accrued during the lawsuit. And then they can issue retroactive refunds to iOS Fortnite users to represent the percentage discount that users would have gotten with a direct purchase of V-Bucks. If they really wanted to protect the consumers while keeping Fortnite mobile alive, that seems to me at least to be a perfectly reasonable solution. That said, there could be some other strategic reason for not wanting to go that route, which just hasn't been made known yet. Epic Games definitely has a flair for the dramatic, so I would not rule out the possibility of some sort of surprise related to this issue. But anyway, long story short, because Epic Games had alternatives for getting Fortnite back onto the iOS App Store, and because those alternatives don't impact the outcome of the litigation in any obvious way, the court was not about to use its power to force Apple to allow Fortnite back on. The moral of the story here? The law helps those who help themselves. If you're not willing to make some moves to better your position, neither will the law. The second main reason why the court denied the preliminary injunction as to Fortnite was basically because there wasn't enough evidence on the record showing that they were likely to succeed on the merits of the case, and the balance of the hardships between Apple and Epic Games on this issue didn't tip sharply enough in Epic Games' favor to allow them to win on that lower standard of proof. As an example, the court pointed to the fact that both sides have hired very well-respected and talented economists as expert witnesses. Also, the court noted that when it comes to antitrust cases concerning business in the area of tech and innovation, it's far less likely that the case will be anything other than highly complex and highly fact-dependent. And given the fact that the two sides have not yet had a chance to engage in discovery, there simply wasn't enough evidence on the record yet to make this kind of determination. But the court had a different outlook when it came to the idea of forcing Apple to give Epic Games and its affiliates access to Apple's developer tools, aka the Unreal Engine issue. There, the court noted that although the affiliates are all related to Epic Games, they each have separate contracts with Apple, and they each pay separate account fees to Apple. And more importantly, they really have nothing to do with the Fortnite update issue. Basically, the court found Apple's removal of access on this issue to be straight up retaliation. And they found that it was incredibly harmful not just to Epic Games and its affiliates, but also all of the third-party small business developers that rely on Epic Games affiliates programs in order to run their businesses. If Unreal Engine couldn't access Apple's developer tools, it wouldn't be able to run eventually. And those developers that rely on Unreal Engine would have to either find new programs for their apps or risk going under themselves. The court basically found that as a result, the harms here are potentially catastrophic and overall inestimable. And given that many of those who would be harmed really had nothing to do with the Fortnite update, there's no unclean hands issue here. So because the relative harms on this issue tips sharply in the favor of Epic Games and its affiliates, the court allowed Epic Games to win on this one just by showing that they had raised serious questions as to the merits of the case. So now that the court denied the preliminary injunction as to Fortnite, Apple is free to keep Fortnite off the iOS App Store, unless Apple loses at trial and is then forced to allow Fortnite back. Trial is set for May 3rd, 2021, so it would seem that that would be the nearest date that Fortnite could come back to iOS devices. However, that's not exactly true. Even though the court denied the motion for a preliminary injunction as to Fortnite, the denial of the preliminary injunction doesn't mean that Apple isn't allowed to let Fortnite back on later. There's nothing stopping Apple and Epic Games from negotiating a way for Fortnite to get back on sooner. Even though Apple technically is the winner on this particular issue, Fortnite has been a significant source of revenue for Apple as well as for Epic Games. So they could both potentially benefit from striking some kind of deal while the litigation is ongoing. And as for what this ruling means for the overall case, as I said earlier, preliminary injunctions are hard to win. Not winning on this issue does not mean that Epic Games' case against Apple is doomed. While it's true that the court found that Epic Games had not met its burden of showing that it was likely to succeed on the merits of the case, it doesn't mean that the court actually thinks that Epic Games likely won't succeed. All it means is that Epic Games doesn't have the evidence yet, and it has to go through the discovery process to get the evidence from Apple to prove its case at trial. So, what do you guys think? Do you agree with the court's ruling on the motion for a preliminary injunction? Should Fortnite be allowed back on the App Store? Should Apple be required to allow Unreal Engine access to the developer tools? Let us know in the comments. I hope you found this informative and interesting, and if so, we'd love it if you'd hit the like button and share it with friends and family. And if you're new to this channel and you want to see more, hit the subscribe button and the notification bell. That way you can find out when the next video is uploaded. Thanks.